I want to welcome you to the Hope for Justice in Action webinar. I wasn't quite sure how to get started with this whole process with regards to doing another webinar. The Hope for Justice workshop is online at the private-person.com website. Everybody who is registered as a member on that site can get access to the Hope for Justice workshop that I did about a year and a half ago now, and it's in multiple sections. Part 2 is password protected. In order to get that password, you have to register on the website, and a password will be emailed to you so you can access Part 2. And if you're already a member and you can't find that access, you can email the member's address on the site there and request the password in order to access it. The first thing that I wanted to address was I did the Hope for Justice workshop, and really not much has changed since then, other than the fact that we've got more experiences and more references to what I covered in that workshop, and as far as I'm concerned anyways, confirmations of everything that, or pretty much everything that was covered there, with additional refinements, with more understanding from studying other people's work and also experiences in court. If you haven't reviewed the Hope for Justice course, many of you were at the live workshop portion and attended the webinars. If you haven't reviewed it, I'd highly recommend you to go and review the material. Just like anything else, the first time you get something, you only get a small percentage of the information that sticks in your brain. And if you review it, you're going to get more, and if you review it again, you're going to get more. And especially if there have been additional experiences that you've had, or additional study from other people, when you go back and review it again, everything is going to look and sound different because you've had that additional information from other sources and those personal experiences, which you're going to be able to interpret the information in any course to a higher degree that's going to be more useful to you. A lot of people who had no real court experience, did not get as much as somebody who had court experience, and once you have a little bit of that, attend a few sessions in court and so on, things make a lot more sense. So I'm just going to cover some of the key concepts that were covered in the Hope for Justice, and the first one, the webinar, was about capitis, and is it or is it not something that is part of the system. Everything that I saw up to that particular time convinced me that it was. I've seen a lot more since then that has convinced me that it is, and so I'm still quite comfortable with regards to the capitis. The big distinction that I need everybody to understand with regards to capitis is that it is valid and used by the system in their civil law court system, so that when they come in with a civil law process, they're using capitis. But if you move it into a common law process, because common law does not recognize the capitis, it's not relevant, it becomes something of less importance. But it's still something worth making sure is correct once you've got the common law recognized. So capitis is definitely valid because they bring it in with capitis, they're bringing it into a civil law, and you want to try and move it into the common law. The public versus the private. A big issue that really I think is the core basic principle of the difference between our legal systems, that we believe we're in common law, we think about it as common law, that is the private largely, and they move us into the public realm, Roman civil law, municipal law, and possibly into trust law and various other things. But the bottom line is the private versus the public, and if we understand the distinction and learn how to get there. The other thing was private person versus natural person. Private person is a term which existed in common law and only in common law. And natural person is a term that was adopted by the civil law and then moved over to also be used in the common law. And for the confirmation, again, the course covers that. The bi-jural terminology information on the Department of Justice website covers that as well. It's an important distinction between the two, because if you use natural person, there are in fact two natural persons. There's the Roman civil law version that exists in the Quebec system, and then there's the common law one. I want to make sure that when I use the term person, I'm going to modify it with the word private, because private only exists in the common law. So that's my understanding and interpretation. Again, my understanding is that there are two courts, the common law and a Roman civil law, that is their separate private type of existence, not necessarily private like us, but it's different for them, possibly trust, but I'm just going to use the Roman civil law as the reference for that in contradistinction to the common law courts. And again, the hope for justice was largely based on the trial of Russ Parisky back in 2000. What I believe was a demonstration of the factual existence of the common law court, and that they will actually honor the common law court. And again, that's a big part of the part 2 of the common law. Claiming your common law status, private person, written and oral. And this is something, it's an additional distinction. Just on the phone today with somebody who was just in court and attempting to make the claim of private person, and the process is largely about you claiming it with your words, not just with some paper filed into the court work. And I'll talk more about that later, but it's important to claim your common law status. And I believe that when Russ used the term natural person back in 2000, they were not making a distinction between private person and natural person, and he was acknowledged into the common law status with that term, which I think is not a problem. I mean, you can definitely use a natural person, but I think there's a gray area with it. Your claim to common law court. So once you claim common law status, it should become a common law court by default. And what we're talking about now, I'll address later as to how to phrase your personal claim and then the claim of the court. So making a motion for an order, this is one of the things that Russ did. He got an order confirming his private status as a natural person. He also got an order to change the style of the name on the document, which was the charging instrument, the information. Those two things, I think, set the common law court in place and confirmed that it was a common law man being charged under their Roman civil law process, which is a misjoinder. So I believe that was the foundation of what happened there. Now, one of the things, again, with court is the understanding that you need to object to and describe any mistreatment, threats, intimidation, loud voices by the judge towards you in the process of being in court. Again, having just listened to some more stories about what people have been experiencing the last 2 months in court, this is an ongoing issue. You need to understand that they will potentially resort to this, and how to prepare yourself for it emotionally, and how to also prepare for answering to it and stopping them from doing it. And file an affidavit after court is everything that was said and occurred. Dean Clifford talked about this as a good process. I agree with it 100%, because anything that isn't officially noted by the court recorder in the record book is not really on the record in the court file. So when that file comes back into the court, the only piece of paper in it is the information. So anything you file after a court attendance is an affidavit which you've sworn about what happened that day, how you were treated, had the behavior of the people there, what you claimed, etc., etc. I think it's a very good process to ensure that the proper record is kept. Persistence to be heard. You're going to get a lot of interruptions and try and get off the topic. Learning how to persist is important. Asking for orders. You have the ability to make a motion for any order you want, and your goal is to learn how to direct the judge, because if you are the common law man in the court, he is your servant, and you learn how to direct him. I'll be talking more about that shortly. Beware of intimidation and distraction. These are the two main things that they're going to do, if you're aware of it, you won't be shocked by it, because when you go into shock, your brain stops working. So learning how to stay on track and not being intimidated. And remember that everything requires your consent. Just by walking into the court, you're consenting to all of the assumptions and presumptions that they're making about you being there. And if you don't challenge them, the assumptions, as far as they're concerned, are factual. They're no longer a presumption of law. They're now a fact for their purposes. So just remembering that everything requires your consent. Consent is also, besides a signature, it's also just not objecting to something. So those are some of the key concepts that were covered in the Hope for Justice course. And we'll be touching on a few of them tonight, because, again, they have become live issues again as more people are in court and more circumstances are facing people. And just a quick update on the Perisky trial so that you have a reference for it. This is the new one, 2012. It happened in the fall of, just before Christmas. It wrapped up. Russ accepted the name in the initial stages, hired a lawyer in the initial stages, which I think is a mistake with regards to an attempt to maintain a private status. He made no attempt to do so, so he was doing what he thought was right for him at the time, and to each their own. And I think that's what's an important lesson for everybody to learn, is different people have different ideas and different theories, and you've got to go with the one that you feel most confident, most comfortable with, not just because of who's talking, but the fact that you've done your research to back it up. So same thing with everything that I'm saying and the people that I'm going to refer you to for further study. It's important to get a broad range of information from different sources and come to your own conclusions. So just a quick review: he accepted the name, hired a lawyer, challenged none or few of the presumptions that I'm aware of. I don't have a lot of direct information on what happened, but this is my understanding of it. As far as I know, made no private property or private contract claims before pleading, which is an important point to do things, because once you plead, pleading perfects the jurisdiction, and everything is deemed to have been established with regards to all of their assumptions and presumptions about the Roman civil law issues. So from that, effectively accepting a non-common law court, which again in my interpretation is some type of Roman civil law or trust type of court, anything other than a non-common law, which isn't there to protect you. And again, my understanding of what happened was that he argued statute interpretations from the taxpayer perspective. So a complete departure from the first trial, where I believe he went in as a private person, natural person, and triggered a common law court, and then had the judge defend him. So the exact opposite route is what I believe occurred this time. And convictions were entered on most of the charges for Russ and Delane. One point to make is that no matter what your argument is with this type of issue, the chances of losing in provincial court are extremely, extremely, extremely high. The chance of winning is very slim, no matter what your argument is, because they don't want to give up the game at the lowest level of court. So no matter what you go in there, you can pretty much expect to lose. So I hope that he appeals it and it goes further up the ladder to find out what happens there. I'm going to touch on some key sources to study and review. Once more, these are largely on the private person website as part of the Hope for Justice selection of information, and it's also on some of the posts. There are regular posts there on topics, and some of these people have material that I've been studying and have found very useful. Batman and Rob Ryder, there's an audio on the website where they're having a conversation. Lots of interesting things are discussed. Batman and Boris having another conversation, and it's a two-part series, and they are having a discussion with some people who are going to court down the normal route, arguing in court, arguing statutes, things like that, and they're trying to provide a separate or a different perspective, more along the lines of having the court do what they're supposed to do to protect a private person. But they're not using private person, they're using some other ideas and concepts. But again, I think it's valuable, very valuable to listen to. Victoria Joy is somebody, I studied her work 10 years ago, and it's about honor and dishonor. It's come up again. I started studying it in the fall, and it's extremely important and valuable information, and it appears to be a part of the court process, and we've just had it confirmed by a lawyer in conversation that yes, honor and dishonor is absolutely part of the process, and I'll be touching that later. Dean Clifford, most of you know about, lots of videos that are on YouTube, and he did a presentation out in Chilliwack, very good information. Part 3, he goes into a lot of information about court. The vast majority of Dean's information I concur with, and I've learned a lot from, and I question the trust process that he addresses, not because I think it's wrong, but because I don't think we really have to go there. And if we're going into common law as a common law man or woman, I don't think we need to address the trust issue. So it's one path to take, and it's an alternative path, and sometimes it might work together with the common law man. But again, that's something for everybody to decide for their own. Glenn Winningham, again, there's videos on the website that are teaching about living a private life, a sovereign man. Some very good information on there with regards to court process and also living privately. Richard Cornforth, again, very worthwhile. Franco Collins, I found some of his information interesting, and actually I did a post about it, and then there was somebody offering a counter to some of Frank's claims, and I posted that as well because I found the counter to be very valuable as well. So there's lots of sources out there. Mark Stevens, lots of information again on there. He's got the Free State Project. Interesting concept, and I think it's a valid concept, but maybe a little bit premature for most people. Jordan Maxwell and Victor Varjabian, there's again a video up there on them. Conversations are very good. All of these different people are covering things from slightly different perspectives, but so many ideas overlap. I think it's extremely valuable to consider them all sources of information to consider and study. Personally, I've listened to this Batman and Rob Ryder audio at least 10 times. There's a ton of information and philosophical concepts in there with regards to how to deal with the courts and your attitude and so on that I think is extremely valuable. And with Batman and Boris 1 Part 2, and Rob Ryder talks about it with Batman, Boris appears to have triggered having somebody from within the system assigned to him, so that this fellow is the person that Boris sends all the documents that are made out to the all caps name to, whether it's a parking ticket or a tax form or whatever. So somehow Boris has exited the system and has somebody within the system handling all communications going to the all caps name. Pretty cool position, I would think. So I think there's lots of good information in here. Obviously there's a lot of information and a lot of time involved, but like anything else, we're trying to get a lot of the garbage out that we've been taught, and having information from different sources, I think, helps to create a very balanced view. So I would encourage you to take a look at those things in the future. If anybody has a question at this point in time, if you want to put it into the chat box or whatever it was called, just ask a quick question before I move on. Nope. Okay, good. So part of my goal here with the Hope for Justice in Action is right now a number of people are facing court, and what do we do and how do we do it? How do we take what we've learned and put it to use in a way that gets us the result we want? And one of the aspects of doing the right thing in court is doing the right things before court, and that's my particular focus is to try and do as much before court as possible so that there is no court. And anything that transpires outside of court and pre-court, I'm tracking for anything to do with how to actually address these folks for their not upholding the law. Now, there's a bunch of different things here. I'm going to try and address them one at a time, so don't read ahead. But this is a quote from a case law in the States. The claim and exercise of a right cannot be converted into a crime. There can be no sanction or penalty imposed upon one because of an exercise of his constitutional rights. No state shall covet a liberty into a, convert a liberty into a privilege, license it, and charge a fee therefor. The citizen can ignore the license and the fee and engage in the act with impunity. And this is effectively what I think what we're doing and what we were doing with the contract for hire and the natural person position, is that we were activating our inherent right to earn a living free of intervention from the government. And my particular stance on this is that I'm a private person in the province using a private contract protected by privity of contract, exchanging private property with another contracting party, whoever it happens to be. And all of those things are the exclusive jurisdiction of the provincial government. in terms of having any potential intervention or say in it. And so my position has been for quite some time that that's my property, and that contract you have nothing to do with. You're not a party to it, and any assumptions or presumptions you make about being a party to it are just plain wrong, because you don't have any evidence of the fact you're party to it. And any money that I receive as a result of that contract is private property, and case law has clarified or stated that the money you receive as income from the performance for work is private property, and private property is the exclusive jurisdiction of the government, the provincial government, if there's going to be any discussion about it. So what's happened here, in my opinion, is that the federal government, through their agents, is making presumptions and assumptions about us acting in their realm because of the social insurance or number or whatever it is. It doesn't matter what it is. The thing is, they're making the presumptions, and those presumptions stand unless we challenge them. And just in terms of understanding the relationship between us and the civil servants, the people created the government, and the government hires the civil servants. So who's higher than who? And they swear oaths of office and are bonded to perform their jobs as servants. All right? If you are a common law man or woman, they work for you because the people created the government, and the civil servants are there to work for the people who created the government. And what I believe is going on is that there aren't any common law men or women going in asking for service from these people. They see everybody as a legal entity in some Roman civil law or trust relationship or whatever, and they are seeing us as a person that they get to enforce statute and regulations on us. So instead of us holding them accountable to their common law duty as a civil servant, which they have an oath to do, they are holding us accountable to statutes which were created to basically rule and control the legal persons that exist in their system. And so if we go to them as a common law man and require them to serve us on their oath, we are triggering the proper hierarchy, which is we are their bosses. We created them. And we trigger their oath and their bond, so now if they fail to do their job, they become personally liable for it. And this is something that Dean has been working on with regards to laying liens and going after lien collections with regards to civil servants and other people who aren't performing on their oath. There's a process where when you're dealing with these people, if you say, I accept your oath, you're basically saying, I know you have an oath, I'm here as a common law man, and you are bound to your oath to serve me and do your job. And if you don't do it, then I'm going to hold you liable. And this is something that we have not done, unfortunately, is hold our civil servants and agents of the government accountable, which I'll address in a second here. So they need our implied consent every step of the way. They're always asking for our consent, and most of the time our consent is just not saying anything, and implied consent. And if we sign something, as far as they're concerned, that's explicit proof of us understanding and consenting. But most of the time, they deem something which is a presumption. And a presumption is not fact. They're just going to pretend it is what it is that they say it is until you counter it with an objection or evidence to the contrary. And this whole idea of deeming and presuming is foundational to how the entire system works with regards to controlling people. And it's been this way for a long, long time. Eric did some research on the word deem in the Income Tax Act, and I think he found out it was in the Income Tax Act like 1,100 or 1,400 times or something. Every time they deem something, they're saying we know it isn't true, or we're not sure it's true, but we're going to pretend it is. Well, every time they pretend, if you bring a fact, the pretending stops. And this Spanish requirement was in 1493 AD. This, I think, is the basic foundational principle which they are using against us all the time. And I'm not going to read the whole thing, but based on the Spanish coming over to the Americas, they were wanting to take over the New World, and they found out that there were literally millions of people already here. And so in order to claim the land in the name of the king, of course, they started to wipe people out. And there was some guilt potentially associated with this. So this law, this document called the requirement, was supposed to be read, whether or not translated into the native language of the inhabitants, to the citizens of every foreign nation just prior to their conquest. The gist of the proclamation was to inform the soon-to-be vanquished that their lands were being donated to Spain. All right? So by reading this quote-unquote legal document, they were giving notice to the people there that they had no choice. It was now the property of the king, and they were just taking it by donation. And this was how they prevented themselves from going to hell, supposedly, for killing people with no legal right and so on. And it's an interesting read. I'll make this available for anybody who wants it. You can also find it. This is actually off of Wikipedia. You can put the requirement into Wikipedia and you can find it. But the idea is that it says here that they would even, from the ship, before they reach shore, read the requirement to the land in sight. And as far as they were concerned, they had met their legal obligations, and they could now go and kill and murder and rape and steal all the property of these people because they had given them legal notice. It's bizarre, but this is how, unfortunately, they appear to be operating to a large degree. So there were hundreds of indigenous cultures here. Approximately 100 million people were killed by disease and war brought along by the aliens. All right, and 100 million approximately were brought across from Africa enslaved. So all of these things are done on the basis of we have this right because we made it legal. We wrote a law, so we made it legal. One of the defenses of the slave traders was, we're not doing anything wrong. It's legal. There's no law against it. We actually have permission. I think it's a pretty sad excuse, but that's what they're using. That's what they've used for a long time. And they get over their guilt by creating these legal loopholes for them to say, well, I gave you a chance to claim common law and you didn't, so I guess you're not. And it's crap, but that's the way they're, I believe, playing the game. So a quick outline of the honor, dishonor. One of the basic foundations is that everything is an offer. And from an offer, you have the opportunity to accept, just whatever it is, accept with a redraft, which is a conditional acceptance. You can refuse the offer, and you can go into silence. And with honor and dishonor, the goal is to stay in honor. If you go into dishonor, you lose. And the first two, accept and accept with redraft, are being in honor. And the refuse and going into silence is dishonor. You now have a fight on your hand. You now have the opportunity for them to make their presumptions and hold their presumptions, etc., because you have either not accepted or not accepted conditionally. So this whole process is, again, just confirmed again by a local lawyer that this is part of the process that they utilize. And so learning it, I think, is an extremely valuable thing to do. And it directly relates to every human interaction that we have. Within some of the information I'm going to make available for study is an example like a husband and wife. And the wife says to the husband, would you mind taking the trash out? Or could you take the trash out? And what can the husband do? Well, he can either accept it, yeah, sure, and go do it. Or he can accept it but redraft it, or and put a condition on it and say, yeah, I'm happy to do that right after the football game's over. Okay, great. So everybody's happy. It's honorable. Everybody's been respected. She asked. He either did it or said, I'll do it after this. So she's happy because she knows it's going to be done. But if he refused, he's dishonored her by just refusing. And it causes tension. People feel disrespected because of it. And you can see this is just a natural process of communication. It's not just in law. And if you go into silence, you just ignore her. Well, that's being disrespectful as well, and she could get upset and angry and all that other sort of stuff. So you can see that these naturally create peace. And these two naturally create antagonism and war, potentially. Okay, so a very simple concept that you can take into everyday communication, and especially into the court. Now, one of the principles, again, in anything, but also highlighted in honor dishonor, is that burden of proof is on the claimant. Right now, the taxman is claiming that the money that you made under private contract in the province is somehow associated with the federal jurisdiction, and their taxpayer made it. Well, that's their claim. Now, if we go into it properly, we can challenge them on their claim and not have to provide any evidence or any defense, because they have a burden of proof to prove their claim once we challenge it. If we go into argument, what are we doing? We're refusing somehow, right? If we're defending, we're refusing somehow. So we're going into dishonor with arguing and defending. And a fight starts, and what do you need for a fight? You need a referee. What's a referee? A judge. Well, if you do everything with honor and dishonor, and you give them opportunity to prove their claim and they fail to, they're the ones that are in dishonor. And this is what the administrative default process is, which we haven't talked about yet, but many of you are familiar with, is that you give them the chance to cure multiple times, and when they don't, you have evidence of their dishonor. You don't need a judge. There's already a proof of dishonor. The problem right now with that is the justices of the peace have been trained not to participate with us in holding people accountable with regards to going into default, even though this is a normal process that they use every day with banking and with real estate. They use notice and default with regards to those two all the time, and they don't want to make it available to us. We have, I know one gentleman working on taking the Notary Association to task for the fact that they're trying to prevent their notaries from performing that particular task for us. So it's an interesting avenue to explore. And the one remedy to ask for is forgiveness. If you go into dishonor and you didn't know, that's fine. People make mistakes. You can always apologize and ask for forgiveness. I didn't mean to, I seem to have offended you. I didn't mean to have offended you. What can I do to, make it right? And you can cure the dishonor with that type of offer. And to refuse forgiveness is going into dishonor. So again, it's an interesting concepts. Encourage people to have a look at it. The main material that I'm studying right now with regards to it, and will offer the opportunity for people to study with me, is the Victoria Joy material. And I have access to a live seminar transcript of hers, and also a home study course. I know also somebody who has an audio recording of one of her workshops as well. So that's the basis of it. You're free to type her name into the internet and find out what you can get on it. But this principle is being talked about by a lot of people, not necessarily with the honor and dishonor terminology to it, but the principles are being covered. Boris and Batman and Rob Ryder, they're all talking about it, not necessarily using these words, but it is a large part of what they're doing. And when I was rereading Victoria Joy's material, I saw a lot of stuff in there that I've been hearing from some of those other people that they're using and getting results with. So again, a valuable thing to look at. Now, with regards to the common law court, this is part of what's covered in the Hope for Justice workshop. The Supreme Court of British Columbia is continued under the name and style of the Supreme Court of British Columbia in quotation marks, upper and lower case. Now again, many people have been using the word spelling when they're referring to the change of case, and that's an incorrect terminology to use for it. It is the style. It's very important, and it's referenced here. Our goal here is to get into this particular Supreme Court of British Columbia. If you're not correcting the style of the name of the charged party to upper and lower case, but it's still uppercase, then I believe you default into the all uppercase Supreme Court of British Columbia and don't get the constitutional one. So important to keep this in mind. The name and style properly done will get you the right court. This is a quote from Sovereignty International workshop, which is the what was his name? Weatherford. Let's see. Winningham, I believe it is the Sovereignty International stuff. So 2 minutes into number 6 of 26 videos, and they're about 10 minutes each, statement to quote their code but not claim subject to it. If you're going into the common law court, you want to basically do as much, if not everything, right as possible. One of those things is to claim your status as a common law man or woman, claim the court as a common law, which it should just automatically become once you're there in that status, and it's, you know, automatic. But use the correct style of name just because. I don't believe you have to, but I think it's good to maintain it. And the statement here is, if you're quoting statute law, it does not apply to a common law man or woman. Statute laws apply to persons that are subject to those laws, which are the people who have applied to be subject to them, or the government employees. So why would I quote a statute law if I'm in a common law court as a common law man, where the only law is do no harm and do no threat of harm to any person or property? That is the only law in a common law court, which is basically being honorable, being respectful. And all the statute stuff is for the all caps persons. So why would I quote statute law? So if you do quote it because you want to reference what the courts have said about private property or about common law or something that is within the common law realm, you can use this type of notice with it, which is that you're further noticed that the use of federal or provincial statute, codes, rules, and regulations within this document is only notice that which is applicable to you and is not intended nor should be construed to mean that I have conferred, submitted to, or entered into any jurisdiction alluded to thereby. Okay, at common law, you should be using public law. Now, this is an interesting distinction. We think of public law as being, you know, for the persons, but it appears that the private law is everything they write for their Roman civil law, and the public law has to do with the common law. So again, research that out for yourself. It's an interesting idea to consider. But if the common law exists for the protection of the common law man and woman, we should invoke it and make sure that we stay within it whenever we are addressing anything to do with the law. Another aspect which Batman and Boris talk about, which I really like, is the fact that if we go back up here to our relationship to our civil servants, okay, we create the government, they're civil servants, they swear oaths to do a job, all right? We don't need to know how to fill out those forms. Those forms are for them. We don't have to understand the statute laws because those statute laws are for them. We don't have to understand their policies and procedures because those policies and procedures are for them. And if we are the common law man and woman, they are working for us, then they are bound to perform when we tell them to, which is, I don't know which form it is. I don't need to know. That's your job. You go get the form and you fill it out and you do whatever process you need to do to deal with this situation in your system, because that's not mine. Mine is the common law. You've agreed to and sworn an oath to perform in that system over there, and you know, go to town, because I don't need to know that. And I really like that idea. I'm sick and tired of trying to learn this law and figure out this system and everything else, and I've come to the conclusion I don't think we have to. There's certain aspects of it which are important to know, so you can come to that with a level of certainty, but when it comes down to it, I don't think we need to understand their game. We just need to let them know that we're not in it, be able to stand on that particular point, and learn how to hold our ground with regards to making them perform. And that's within, I believe, the common law court, and also going to these agents and to these court clerks and stuff like that, putting them on notice, accepting their bond and oath, and letting them know that we demand their performance as a common law man or woman coming to them. So ultimately, my position is that the feds have no jurisdiction in the province for property issues. And so a private person in the province under private contract is related to private property. Nothing to do with the feds. Okay? All four are common law issues. All four are exclusive jurisdiction of the province. What's that got to do with the feds? Nothing. And we have to overcome the presumptions it does and get them out of it. So the feds presume a federal person. They presume commercial public business. They presume performing a function of government. I did a web post on, or a post on privateperson.com on this performing a function of government issue, which I'd heard from Dean and some other people. They didn't provide a reference, so I went looking for it, and I found it in the Canada Evidence Act. So if you want to learn about this, go and just type in performing a function of government on privateperson.com. You'll find the post on it and a little video I did on it to overview the idea. But ultimately, this, I believe, is how they're bringing evidence into the court, because everything that they call a business record is defined as something that was made during performing a function of government. And so whenever they bring our business records in on a tax charge under the Canada Evidence Act, you go and look up the definitions, they are claiming that those records were made while performing a function of government. And if you weren't performing a function of government while those records were made or those documents were made, I think that's a presumption which can be challenged, again. So few people realize that whenever the word application is used by a government agency, it typically means application for benefits. For example, when you fill an application form for a driver's license, social security card, or bank account, you're probably applying for a benefit to be provided by a government trust. You can't normally receive a benefit without being a beneficiary, and beneficiaries have no legal rights. Thus, by voluntarily filling out an application, you may unwittingly forfeit your claim to any legal rights or standing at law, which is your common law, relative to the trust property. And this is where it gets into trust issues. Again, I don't want to learn trust law. I don't think I need to learn trust law. All I need to know is that it creates a trust, and I don't want to be a part of that trust. And so not filling out application forms. And I recently heard from one source some interesting ideas with regards to challenging matters with regards to, for instance, the driver's license. For instance, police officer pulls you over, you happen to have a driver's license, he asks you for it. One of the things that this person said was, as he's handing the driver's license over, he says, I'm providing this to you because you've demanded it. It's not mine, it's the property of the province, and I only have this in order to prove competency. I am not providing you this in order to provide identification to you. It's not to be used for identification purposes. Do you understand? And that's interesting because many, many years ago when I went in for a driver's license renewal, I noticed that the form you got from the guy at the driver's test was effectively a certificate of competency. That paper was then given to the person behind the counter, and that certificate of competency was turned into a driver's license. So there's two stages with the driver's license. One is fulfilling your common law duty to ensure you're competent and not providing a risk to other people by not knowing how to operate a car safely. So you get the competency certificate to prove that you've fulfilled the common law duty to not provide a risk. And then without knowing it, because they don't tell us, they convert it into a license issue, which is a privilege. You're now bound by all those statutes. So this fellow's way of dealing with having a license and handing it over and using that phraseology effectively says, I'm forced to carry this because if I don't, you might harass me, tow my vehicle, cause me problems, beat me up, I don't know. So I only got this because I want to be responsible and prove responsibility by having done the driver's test and proven I can do this properly, but I'm not using it, providing it to you as a driver or as identification for a driver, just for proof of competency. Now apparently he's had success with that. I don't know, I haven't tried it, but I find it an interesting concept and a fine distinction of how to separate those issues, and something to consider with maybe some other things. There's many little tidbits that are out there in these videos and other educators, and lots of stuff going on in London with regards to all this, and all around the world. This is a very big deal all around the world. People are trying to figure out the system and how to reclaim their natural status and not feel like they are beholden to the government. And I believe that comes from rediscovering our status as a common law individual, and standing on that, and then binding these people with their common law oaths to actually perform for us. There was recently somebody who was in Kelowna who was in court and having an adventure with regards to a tax charge. Whenever you go in on an issue, you have a summons. And just like with Russ's first trial in 2000, he stood outside the bar, claim common law status in a common law court after presenting himself as a private person in his private person status there at the court. The judge acknowledged him in that status and changed the style of the name on the information to the correct style, upper and lower case, after being asked to. No big deal. We're talking like just a few minutes here. Very similar again to what happened in that first Parisky trial. One of the new distinctions with regards to this is that once you've set this common law court, if you are in fact the common law man and you understand that it's now a common law court and the judge is working for you, what's possible to do at this point in time is to get the judge to do the work, which is great. Now now the information's been changed, so the charge is against a common law man. Where does the Crown get the right to bring a charge against a common law man from a statute? It's a really good question to ask. And this fellow, at that particular time, and again, when you're in court for the first time and you're not used to it and you're studying all this stuff and everything else, you're going to forget stuff. It's a stressful environment and so on. Instead of challenging the Crown's right to continue the case, he consented to another court date, which is, again, part of their distraction tactic, is they invite you back, or they ask you questions, or they say you can't do this, you got to do this, and they get you going off in different directions. So just by inviting, instead of saying, well, I don't think I should have to come back because now it's a common law matter that the Crown is bringing a statute to, please ask the Crown to demonstrate how they can bring this common law matter, and there's a specific way to do that as well. But the basic issue is that once you have the judge in the position where you're in common law, he works for you now, and you can move him to do things for you. The judge is not our enemy. The judge is our friend if we are in common law. And we have to learn how to direct the judge to do what we can direct him to do, and we are empowered to do, but we have to understand that we can. And one of the things that could have been done there was to motion the judge to get the Crown to prove how they could have standing. We consented to another court date, which turned into an exciting time because he stood outside the bar and reclaimed the common law status and the court status. But he stayed outside the bar doing this instead of going in, which would have been the preferred thing. Once you claim status, don't worry about the bar. The status eliminates the bar. Remember, the status is all part of the fiction. You've claimed common law, which is real. Now the fiction disappears as far as the real is concerned. And the judge is now common law on your side. By staying outside the bar, he went into dishonor because the judge said, come in or leave and an arrest warrant will be issued. Well, he wasn't sure what to do. His brain got fried and he stood there. And the judge issued an arrest warrant for him. Unfortunately, it was the end of the day, so they put him in jail overnight and brought him back the next day. So, remaining standing still, the judge ordered the arrest and stormed out of the courtroom. The judge was upset because of the challenge and so on and what was being brought before the court. But if he'd left, would have got an arrest warrant from what the judge said. But if he'd gone in, because he'd already claimed common law, and because the information had already been changed, then other issues would have been able to be dealt with. But we all learn by making mistakes. I've made my share, and I'll make plenty more. They arrested him, booked him, and kept him overnight. He did sign a recognizance of bail to get out, and that's basically confirmation you're going to come back to court another date. And that's all fine. The best place to deal with this stuff is in the court at this particular time and not make a big deal about it. You can sign things with regards to your signature if you want to, but the goal is to get out and get back into court. And we don't know what the outcome is yet because it's coming up tomorrow. But my understanding is he's going to be making a motion for discharge dismissal for want of standing. The information's been changed to upper lower case. It's a common law case now. And how does the Crown sustain that? And we'll go into that in a little more detail in a second. There's other people who are in court. There's a lot of activity. It's unfortunately reminding me back of 98, 99, 2000 when I was attending court multiple times a week, watching trial after trial after trial of people going in and doing appearances and challenges and trials themselves and so on. And things are heating up where there's a lot of court activity again. If you want to learn anything about this process, I highly recommend you find out when some of these court dates are going on and go and support these people. It's very nice seeing other people in the courtroom. You're witnesses. You're also emotional support for these people, and you will learn an absolute ton by being there and seeing this play out. There is nothing like seeing yourself to see the games the judges play, the tricks that the person standing or sitting in the hot seat is missing, because you can see it, but you're not in the hot seat, and lots of good lessons to learn by attending. So find out when those things are and attend. And with regards to this whole court process, we had, or I had somebody that I'm working with have a casual conversation with a lawyer who is in business law and has his own company and so on and so forth with regards to setting people up into business and corporations and various other things. And having a private conversation just about stuff. They like to talk about various theories and law and so on. During this conversation, this lawyer blurted out, or not blurted out, but actually popped out a statement with regards to common law. The issue of being Roman civil law was raised, and the lawyer confirmed, yeah, that's exactly what it is, and if you want to claim common law, this is how you do it. And I think that got a little bit of attention there, because here was a lawyer saying, you're right, Roman civil law is the game, and common law is not the standard issue. You have to claim it in order to get it. Even though we're in a common law province, in a common law country, we still, at this particular point in time, it's default system into the Roman civil law, and we have to actively, proactively claim common law. So this is what the lawyer said is the statement. This is a direct transcription off of an audio recording of what the lawyer said. I do not accept the jurisdiction except under common law as established by the Magna Carta. Accordingly, the prosecutor has to prove harm before he can proceed with his complaint. There is no harm, therefore there is no contravention at common law. This is a lawyer saying this is what he would do if he were faced with this type of stuff from the feds on tax charges. And ultimately, it's a confirmation of the Hope for Justice stuff that I've been doing to a large degree. My focus on the private property in the province with private contracts, because it's all private and it's all common law and it's all within the jurisdiction of the province. And with regards to a common law claim, there's only one claim, harm. If there's no harm or no threat of harm, there is no contravention at common law. And this was his suggestion as how to set the common law in the courtroom. And again, once you claim your status, the court becomes that court. The court, as I mentioned in Hope for Justice, is not set before you get in. The court is neutral, and when you walk in, it will determine which court it is based on who shows up. If you show up in your common law status, it becomes a common law court. And your status is superior to a statute law or regulation issue that is being brought by any other party. And this lawyer here basically, that's exactly what he said. Where's the harm? And if there is no injured party, there is no case. The Crown has no standing to continue this, so dismiss it, or I think the proper term is discharge it, because they have made a charge, and the proper thing to do is discharge it, because they cannot sustain it without an injured party. There are two other elements as well to the idea of injured party, but without an injured party, they don't have those elements for sure, which is a competent witness, and that competent witness can only be an injured party. If I come and I don't do this sort of thing, so I'll use somebody else as an example. If somebody beats you up and you want to press charges, right? You go to the police, you say, this guy beat me up, I want to press charges. You fill out an information about what happened, and they take your testimony, and then they go and do their investigation and press charges. But if you decide that you don't want to give testimony in court, they have to drop the charges because there is no competent witness anymore. You've refused to testify in court, therefore they lose the ability to prosecute. And the only one who can say the law was broken, harm or threat of harm, was the injured party. And it's the exact same thing here. There is no injured party. And what you'll read in transcripts, and you hear prosecutors spew out from their side of the courtroom, is that, well, the public is the injured party because they haven't gotten their tax money. Well, the public is a fiction. The government is a fiction. The Crown is a fiction. There is no harm to a fiction. So this is the difference between reality and fiction. Which reminds me, came across an email that somebody sent with regards to a link. There's a law site
It's 20
in the
hours.
U.S. which the #2 reading material that they give for their students of learning law is Alice in Wonderland. #2 on their list of things to read, because Alice in Wonderland probably is the insider story about how things work in the mirror world that they've created for their court system. So that's kind of cool to get that type of, there was more information. Well, the other thing the lawyer said was absolutely honor, dishonor is a big part of how they play their game in there. And don't expect to win at the lower court. Expect to have to go and appeal to the upper court, because they're playing games all the time, and he's aware of it. I've talked to numerous lawyers over the years. The ones who are actually good lawyers trying to do good but don't understand the game either, that's what they say. They basically say it's fixed, you don't stand a chance, forget it. And that's only because people are fighting in the civil law courts, where everything is fiction, everything is opinion, the facts and the law don't matter. And if you listen to Boris and Batman talk, they would use the term "facts are on the moon," or the facts are on the moon as far as the civil court system is concerned. They just aren't even anywhere near the court, and that's effectively what appears to be the case. So honor and dishonor is absolutely a part of the system. And with regards to what he would do to fight a tax charge, he said he'd fight on one issue and one issue only. The federal government has no jurisdiction over private property in the province. Period, end of story. He says the courts have alluded to it, but they've never ruled on it because nobody's hit it directly on point. He said one of the problems is people go in with 10 different arguments, and then they BS their way around a bunch of the arguments in their decision and ignore the one argument which was the winning argument and was the real issue and was the real point. And he says if you give them one thing to decide that they cannot decide because this is the fact of the matter, then you bind them into a situation where they can't evade, they can't ignore, they can't play games around not addressing the real issue. So as far as he was concerned, the real issue was no jurisdiction over private property. And if your income under a private contract is considered to be private property in law, it's outside the jurisdiction of the federal government. So that was pretty cool confirmation from that lawyer. Always good to know. You never know what information is going to come from where. So I'm just going to pause for a minute and see if anybody had any questions. If you have a question, you can raise your hand on your chat box thingy there, or you can, oh, there's a hand. Okay, so Jim, I'm going to turn on your microphone so you can ask a question. Okay, you there?
Yeah, I'm here.
Okay, what was your question?
Are you recording this, and will it be available on the website?
Yes, there is a recording being made of it, and if everything works out, it will be made available, yes.
That's awesome. This is phenomenal information. That statement from that lawyer, that's priceless, I think.
Yeah, it's amazing how people keep on thinking lawyers' statements like this are priceless and wonderful, yet they're the people that we hold in high disdain most of the time when they disagree with us.
Yeah, isn't that the truth?
That's right. Like when a judge comes down and makes a decision that we agree with, we think it was a good decision. But everything else we think they're lying and cheating and stealing on. So, go figure.
They're just doing their job. And
that's right. That's right. Any other questions?
Nope, that's it.
Okay, great. Anybody else have a question? Oh, we got a whole bunch of questions here over in the question box. Let's see here. Let's see. Okay, second here. Okay, somebody asked what happens to Russ now. I don't know what happens to Russ now. It's up to Russ whether he appeals the decision or not. If he doesn't appeal, actually, there's one more step. There is sentencing. So they have a sentencing date in 3 weeks or 4 weeks or something like that, where they go in and the Crown will be recommending sentencing. In this particular case, they're going for jail time as usual. And there's an opportunity for Russ to argue why jail time is or isn't appropriate, or how much, and fines and how much, and so on. So the Crown will make a proposal. Russ has the opportunity to argue why it should not be that, and then the judge will make a decision based on those parties' input as to how much of each of those he's going to impose. And Russ has the opportunity to appeal the decision itself, and he has the opportunity to appeal the penalties associated with it. So whatever he does, I don't know yet. Let's see. You mentioned that we should be a common law man so that we're not captured by the statutes, that we don't want to be a person. How does that jive with walking into court and saying that we are a private person? Isn't that just a person when then not a man? Absolutely. The term person, just like every other term, is neutral in the English language. But once you move it into a legal environment, it can take on the definitions of that particular legal environment. And the term person in one statute may be redefined in another statute or in a different law, and so on. So even person itself can be redefined. But if you modify the word person with the term private, you are through that informing them that you are in the common law jurisdiction. Now, if you don't want to be a part of any legal system, you want to be totally outside the law, and this is where I see the sovereign movement, the sovereign man and woman thing. If you want to do that, that's fine, and that's where you don't have any capitalization on any of the letters of your name. But when you do that, you're not recognized by common law either. You're actually outside the law. And in order to be be recognized in common law, have standing to be heard, you need to step into the legal system with a person. So the entire legal system, it's all fiction. Even common law is fiction, okay? Because it's nothing but agreements is how people are going to play this game of living together. But it's the first and lowest form of fiction where we have the least loss of rights. So it is a fiction, so it is a person. But if we modify the term with private, and this is the original term used in common law, you can still find it today in provincial statutes. You can still find it today in certain federal statutes, the term private person, because it's only applicable in the common law. So if you want to go into the court and receive the benefit protection of the common law court, you need to be a person recognized by the court, and that status is private person. So it's not the word person that we're necessarily afraid of, it's how it's being modified or assumed or presumed to be that is the issue. So I hope that that answers that particular question. So you can be a man totally outside the law, or you can be a common law man, which is a private person, inside the law, actually inside that particular fiction we refer to as common law. Oh, there it is. 3,800 times deem is in the Income Tax Act. Thank you, Eric. All right. What is the website? The website is private-person.com. So private-person.com is the website where you'll find the course on it and other posts of hopeful potential interest. What mistake do you believe Russ made in his recent case? I don't know if you call it a mistake. As far as I understand it, Russ made a proactive choice to accept the jurisdiction of the court as it was laid out for him and argue the case as a taxpayer, seeking the protections of Supreme Court decisions with regards to a taxpayer. So it's a different angle of attack on the issue by saying, okay, I'll be a taxpayer. The Supreme Court has made these decisions which protect certain actions of a taxpayer, so I'm going to use this legal defense in order to justify my actions. Unfortunately, in that system, the facts are on the moon. And it's all opinion, and when they want to give you the decision for whatever reason, they'll give you the decision, and when they don't want to, they won't. So, you know, if there is a mistake, it's accepting the jurisdiction of the Roman civil law court over a taxpayer. I don't see that as a winning strategy, especially when they have $1 billion a day game that the CRA plays. They don't want to give that up easily. So I wouldn't do that, but again, different strategies and different interpretations, and that's the route that, from what I understand, that he's chosen. What do we claim if we are presented with a search warrant at your home? Okay, search warrant at your home. Good question. Been there, done that, but I wasn't home when they came in the door. So. Bottom line is that when people at your door with a gun, because they come with police, there's not a whole lot you can do in terms of preventing them entrance. What I would do now, if that situation for myself, I would meet them at the door, step outside the door, look at their paperwork to determine if I considered it valid or not, because all their paperwork is invalid. And I would challenge them on the validity of the paperwork right there, saying that this is no good. This is just, you know, a piece of paper that, you know, is trying to look official, but it's not. And you don't have any jurisdiction in my private home for this. And I do not consent to any search of the home. And that's where the police will step in and start to, you know, negotiate and you know, trying to get you to cooperate because you're just supposed to move out of the way like everybody else. The big thing, I believe, is to make your stance, to call them on the paperwork as being invalid. If you have any understanding of that, it's easier to do. And secondly, to put them on legal notice that you do not consent and you do not consider this a legal, valid search warrant. And that you could furtherly put them on notice by saying that by entering my private home, going through my private things, I will consider you to be trespassing, and because you have police here, it's armed trespass, and I will find you, each and every one of you, personally liable and sue you. That's what I do now, based on what I understand. Now, the key to that is actually backing up your warning of suing them. And that's one of the steps that I want to talk about next with regards to the action step. Because really, they're going to continue to abuse each and every person they come up to, whether they claim common law or not, just because they can, just because they can't know. Most people don't know what to do or aren't willing to follow through or will never sue them. They're winning by default all the time. And the basic principle of common law is that we are all peace officers, and I will talk about that in a minute. And we have a duty to report a crime, and as far as I'm concerned, those searches are a crime, and it's our duty to report them and press charges. And no, I don't think shooting back is a good idea, but anyways, there's a comment here: write up a notice and give it to them before they go. Have a witness. Absolutely, if it's possible to have a witness, if it's possible to record it, having a no trespassing notice on your door potentially. Any legal notice with regards to your private property and no trespassing, I think, is beneficial, because once they've been put on notice, they have no more lawful excuse that they didn't know it was private property because you gave them notice. They are going to use the fact that, you know, I have a lawful excuse because I have this warrant. Well, once the warrant's proven invalid, the only thing they can rely on is the fact that, you know, they thought it was a valid warrant, okay? And I think that's a weak argument once we challenged them a few times on it. So that's all the questions. Great, thank you very much for those questions. That's great. The reason I refer to this as Hope for Justice in action is because we've all done the whole process of, oh, I'll just lay low and hope they don't come after me, right? Or they'll come after somebody else first, and they'll figure it out, and then I'll get the secret password, and then I'll be able to use it too, and all that sort of wonderful stuff. Unfortunately, even with the secret password, you have to know how to use it. So we're going to talk about that in a second. And we're all guilty of it, myself included, of putting things off because we don't want to do it. And one of the things I was thinking about recently was, you know, in the West before you know all the established courts and stuff, there was a sheriff in town, right? Well, who wanted to be sheriff? Not me. I don't want to be packing a gun and have bad guys coming and shooting at me stuff, and I don't want to enforce the law with everybody and everything else. And you know, the sheriff's the first guy to get shot, so I don't want to be the sheriff, right? So there's that whole idea of, you know, I want somebody to protect me and I want somebody to do that, but I don't want to do it myself attitude. And unfortunately, that's not the way it works if you want to maintain your freedoms, as we're finding out in the United States and Canada. Our freedoms are being, you know, slowly, if not rapidly, removed. And it's not that they're being removed, it's just that we haven't been standing up for them. And this is actions that we can do and why we might want to do it. Came across an email recently. Somebody sent this out, a newspaper clipping from August about the Governor General giving a speech to the Canadian Bar Association in August 2014. And whenever I get stuff like this that I think is of not interest to me but may lead somewhere, I go into Google and I use Google in a really interesting way. I type in Governor General speech August 14th and I see what comes up. And guess what I find? I find the actual speech itself. I'd highly recommend people look at this and find out what the Governor General said to the Canadian Bar Association. And this is like a quote from his third paragraph, I believe. This is a quote from the Governor General of Canada asked to speak to the Canadian Bar Association. When I was asked to serve as Governor General of Canada, I had much to learn. Despite my background as a student of law and a professor of law, he actually taught law at one of the universities for many years, I had to relearn our Constitution and its conventions, as well as its legal principles. And in so doing, I have developed an even more profound admiration for how precious the rule of law is in our country, and how thin and vulnerable its veneer can be. Who is the Governor General? What is the Governor General's position? That's the representative of the Queen in Canada, right? So this is the guy who, or the girl, who should know what the principles of the law that the Queen is accountable to. This guy was a lawyer, and he was a professor at law at one of the leading universities for years before he became Governor General. Yet, when he became Governor General, he had to do what? Relearn our Constitution and its conventions and its legal principles. What, he didn't know these already? What was he teaching in school, right? And profound admiration for how precious the rule of law is. What's the rule of law? It's not the rule of statutes, it's the rule of law. And how thin and vulnerable its veneer is. Yeah, like when you go into court, how thin is the veneer if you claim common law and poof, it's common law. And you don't, and it's not. I would say that's a pretty thin veneer. And we're vulnerable when we don't understand that. Is it going to be that easy for you when you walk in and claim common law? I don't know. If you walk in with confidence and certainty and you've done your studying and the judge can tell that you know who you are and that you are taking control of things, I think it'll be a lot easier than if you go in going, I think I'm a common law private person. Is that okay? And unfortunately, that's the first thing that a lot of people do. And it doesn't get a real good response from the judge, usually. And we have cases that were covered in Hope for Justice where people walked in, said, hi, I'm a natural person. And the judge says, hey, welcome, come on in, the court's yours. You know, I think it's possible. We have proof. We have proof. How much proof do you need? How many judges do you need? How many lawyers do you need? How many individuals' experiences do you need? Right? It really does come down to how much do you need to go on faith and claim it with confidence and do it. And I found this interesting read, reading his speech. It's a little long-winded at certain points, but there's interesting tidbits in there. Now, this is an interesting distinction for myself, and this is how I explain it to me. I came across a book that was about educating police officers in terms of what their obligations were, what the laws were that they had to make sure they didn't break, and what their procedures were when they were arresting people, frisking people, and all that sort of stuff. And in there it says that everybody is a peace officer, not just them. Okay? They are a peace officer first. And what's the duty of a peace officer, and that's a common law term, is to maintain the peace. What is maintaining the peace? Maintaining the peace is do no harm or threat of harm to person or property. Person in the neutral term. Don't get hung up on the fact it's corporate and all that sort of crap. In common law, person is neutral. Okay? So do no harm. Do no threat of harm. You're keeping the peace if that's what you're doing. So you're living your lawful life when that's what you do. But you also have a duty to keep the peace. All of us are the eyes and ears of the law. We're all, in common law, assigned the position of peace officer. So we have to keep it ourselves. But we also have a duty to report crime when we see it. Because there's a principle in law that if you do not report a crime, you are considered an accomplice to the crime because you allowed it to continue, not necessarily occur, but you allowed the person to get away with it so they could continue potentially harming or threatening other people because you did not report that instance, and that person will not be held accountable for it. And we have a duty to intervene. If we see somebody being harmed or we see the peace being broken, we have a duty as a peace officer at common law to intervene and try and keep the peace. Not get ourselves injured and get ourselves into dangerous situations, but do something to assist the situation to try and keep the peace. And if we are failing in that duty, then we are participating through our acquiescence to those things that are going on, which includes when police officers are abusing citizens, when judges are abusing people in the court, when lawyers are abusing people, etc. All right? When we're being abused, trying to uphold our rights and live lawfully and so on. If we don't complain through a legal process, we have abdicated our responsibility as peace officers to keep the peace. And I believe that this is the core reason why we're in the situation we're in, is nobody wants the trouble. Nobody wants to take responsibility. And guess what? In the course, I talk about what is a private person of full capacity. All right? Before you're 18, what can you not do? You can't enter a contract. Why not? Because your parents are legally liable and responsible for you because you're considered not to be old enough to know the difference between right and wrong. You can still make mistakes and your parents are going to pay for it. But once you turn 18, you're considered by the law to be old enough to know the difference between right and wrong. And you're now personally responsible for your actions should you do something wrong, and you're personally liable for something should you do something wrong. So to be a private person of full capacity at common law, you need to have knowledge of the law, you need to be responsible to hold and keep the law for yourself and others, and be liable if you don't. And I think that's where we're falling down as individual citizens because we're trained to be irresponsible. We're trained to point the finger at other people. We're trained to let the government do it. We're trained to get an expert in to fix the situation instead of taking responsibility for ourselves. We've been trained into dependence on outside experts and outside systems and outside governments. We no longer have independent, self-responsible, knowledgeable, fully liable common law men and women walking around saying, hey, I have a duty and I'm going to fulfill it. And I believe that that type of attitude shift has to occur in an individual for them to regain their common law status before the court and your common law status to be recognized by the system. And if you don't exhibit that in your attitude and your behavior, then they will consider you to be a minor still and treat you as such, as a ward of the court, that they need to protect other citizens from you because you obviously don't know the difference between right and wrong and might harm somebody. So they step in and they protect. So this whole idea of being peace officers at common law and what that duty entails, and that we all are as common law men and women, we should potentially investigate for that ourselves and decide what to do about it. So what are the things that we can do as peace officers at common law, right? We can gather evidence of crimes, lay charges and complaints. Anybody can go down and lay a charge or a complaint at the police station. What type of crime have you been familiar with lately? Oh, I don't know. Is the Crown coming in and claiming your private property as federal property, sending you tax bills trying to convert your private property into their money, their gain? That's some type of fraudulent conversion. They're doing it through the mail. That's mail fraud. They know that's private property. They know they don't have the right to it, but they do it in spite of that because nobody challenges them, nobody lays the charges and complaints against them, and this is the next step, getting Hope for Justice in action, is getting people to the point where we can take these steps and take these actions in order to stop these things from happening to the individuals who are taking the actions, and ultimately putting these agencies on notice so they go back into their box and obey the law. No need to obey the law if they're never held accountable to it. That's the bottom line. So what do we gather evidence about? Well, hey, justice of the peace. They are empowered to issue informations and summons and warrants and various other things. Guess what? They have duties to do certain things before they issue those forms. And they're not fulfilling those duties. And we can make sure that they do fulfill those duties by complaining about what they're doing to the Attorney General of the province, who is their boss. If we can't sue the Justice of Peace for not performing their job, we can sue the Attorney General for their failure to train and enforce the Justice of Peace to do their job properly. Right now, they are issuing service against people they know are private persons, they know have private property, they know is a private contract. The JPs don't know this, but the CRA agents are presenting them, false information in order to do that. And because the JPs are not doing the proper inquiries, they're subject potentially to some type of censure. So that's just one thing. The Department of Justice of the federal government, prosecuting people exercising their rights. Hey, I operate privately in the province under private contract with private property. I'm exercising my right to do that, and I'm, being harassed for that. Well, the federal government, Department of Justice knows that. The CRA agents don't, but the upper people do. They're all possible to be sued, okay? Banks, this is an old favorite, okay? They're conspiring to prevent people from opening private bank accounts by demanding ID and putting people into retail deposit accounts instead of a personal deposit account with no ID, no birth date, no address, nothing but a name and a signature on a signature card. That is available. That is the actual private personal deposit account that every one of us should have access to, but they don't want us to have. Not too hard to collect evidence on all of these things. Employers refusing to hire people by not providing social insurance numbers. That's a discrimination case. Where's your right to work if you are not able to get hired without a social insurance number? Where's your right to keep your income private because you don't want to participate in a social insurance type of contract? You sign a form with an employer for them, giving them permission to deduct. Withdraw permission for them to deduct because you want that income to be paid to you privately as a private person, and see what happens. So those are issues that excited people might want to take up. Local police and RCMP, they're harassing people in the lawful exercise of their rights, whether it's driving a car, not producing ID, not investigating and prosecuting police officers or government agents. These are all places that they are not performing to the law, and they could be held accountable for. They're known for falsifying evidence, not getting charged properly. They're known for violence against people, and they're not getting charged properly for it. All of these things are available for people who are in these situations or want to pursue this as a hobby. Fun hobby, eh? I don't want to be the sheriff. All right? Lawyers and judges, my goodness, they're performing all of these acts of mysterious magic tricks in the courtroom. Lawyers bringing charges against private persons that they have no right to bring, ignoring the evidence, the exculpatory evidence that the CRA agents have, and they're saying, well, the CRA agent never told me. Well, you know what? They're liable. They have responsibilities and obligations. They're not fulfilling it. They're standing in courtrooms and they're defaming the accused. They are putting evidence into the court which is not proper evidence. They're doing lots of wonderful things that if they were properly held to account, they wouldn't be doing. And if you read the Governor General's speech, he addresses this directly, that the entire legal system needs an overhaul, that the lawyers and the judges are not performing the way they're supposed to perform. And it's a pretty good kick in the pants from the Governor General, being a lawyer and a law professor, and now having to relearn the Constitution saying, hey, our lawyers and judges are not following the law. Okay? So there's opportunity there. All of these things I consider to be projects, and different people can undertake them. I'm not going to undertake them all because, hey, I'm only one guy. This part of this whole process here is to create the opportunity for you guys to think about what you might want to do on your own or in conjunction with other people. The HST was a great first step, I think. This, because the entire system runs on consent. These politicians exist on the myth that we're allowed to do what we do because we got consent of the people. It was the consent of the people that the HST was brought in because nobody complained when they were trying to bring it in, or at least not loud enough. But once it was brought in, people complained loud enough that it's gone or going to be gone shortly. Okay? Guess what? Could do the same thing with the GST. If enough people stood up and said, get this thing out of here, it would be gone. The Bank of Canada, with regards to them not issuing money interest-free, that's another issue. If made large enough and loud enough, forcing them to obey the law and their constitution to issue money at no interest and stop borrowing from international bankers. And the feds invading the provincial jurisdiction in all sorts of ways. Pick your project. Maybe you're a boater and you don't like some of the stuff going on with federal boating stuff. I don't know. Maybe you're a gun owner and you don't like some of the stuff with the gun stuff. Those are all projects for people with particular interest. But I believe all of it begins with the proper foundation in common law, coming from your position as a peace officer in common law, and in creating an opportunity to collect evidence and then laying complaints. And again, there's ways to do this. So the question is, what will you do? If you read the Governor General's statement or speech, he says this at least 3 times in there. It's the situation is this bad. What will you do? The situation's like this. What will you do? It's up to the people. And numerous times I've heard politicians and I've heard, people in positions like the Department of Attorney General say things like that. It's up to the people if they want things done. And there's all those opportunities to fix things, but we have to go and fix them. We have to take control of those things. And it's not going to be just one person. It's not just going to be 10 people. It's going to be like what happened with the HST, where a movement got started and things kept happening and kept growing and growing and growing. And I see that this is an opportunity growing around the world where people are stepping up and taking actions. So there's all sorts of action teams that could be done. They're volunteer, self-forming, self-motivating, self-responsible. Gee, sounds like common law people getting together and deciding to do something. Pick a project. I've got lots of ideas. If anybody wants to chat about ideas, I can help lay out some of the processes and procedures I see as beneficial. But this is not a top-down deal. This is independent people deciding to work on a project and finding team members to work with and doing the job and getting it together. Idea being focused projects. So I can suggest some projects. Also create your own projects. And the idea is to compile research into actionable steps that anybody can do, like how to lay a complaint against a police officer. There are already processes in place for that. You can go to the certain law sites, the Department of Justice website, or the Vancouver Police Department, or the RCMP, and there's already how-to information there. So being refined and any other steps that can be added to it, or how to go after a JP. What are their standards that we can hold them accountable to, and so on. And compiling that research into educational material. One of the reasons I'm doing this is because as I compile this information to spread it to you, I learn it better, and I become more informed of it with new distinctions and so on. So by me compiling the research that I'm doing and sharing it, I get more knowledge from that process, and then the feedback of everybody assists, and then I have contact with people having experiences, and they share their experiences with me, and I learn from that, etc. And the same thing can happen with you if you want to. And the idea is to share that research with everyone who contributes to a project, and if multiple people are on multiple projects, we all share the results of every project. Instead of one person working on 5, 10 different things, you got 50 people breaking it up and doing the work, and I think that's the way it's really supposed to be done. And why? Why do this? To pressure excuse me, to pressurize the civil servants, the lawyers, the judges, the government agencies to follow their already written policies and procedures and the laws that bind them, not us. Only private persons of full capacity can and will do so. So the Tom's manuals that the income tax boys might occasionally refer to but never follow, they should follow it to the letter. It's there for a reason. And if they're not following it to the letter, it's our job to hold them accountable to it because they're not doing it. And there are policies and procedures for every organization, and they need to be hammered on it in order to make sure they're following it. And, you know, I know it doesn't sound like an exciting thing to do, but if you're doing all this legal research anyways, how would you like to use your legal researching time for a project that's actually going to have an outcome of creating a change instead of just learning for learning's sake and hoping nothing happens to you? So that's just food for thought. And I create that as an opportunity for you to consider action steps and give some feedback with regards to, you know, what you might want to do. I am not looking to lead anything. I am not going to lead anything, so don't anybody go there. If we want to get together and talk about ideas, share ideas, and people can volunteer into whatever they want to volunteer on, great, wonderful. I'm just trying to plant some seeds that maybe will get fertilized a little bit by people who want to go further. Does anybody have any questions or comments at this particular time? Either raise your hand or, oh, there's a couple more here I'll answer. All right. Let's see. Getting used to this. Let's see. Warranton House, getting used to this. Go to Criminal Code Section 39, reclaim of right. Have that in place, and no matter what their claim, any attempt to enter is an assault on your person. Oh, very cool. Okay, thank you. So Section 39, here, I'll copy that. In the chat box, here's a quote. Is that everything? Section 30, is that whole thing going there? There we go. So I just, in the chat box, I sent you a little text here from one of our callers. 39, reclaim of right. So that would be a good thing to review for anybody interested or concerned about search warrants on their home. Yeah, that's great. Thank you. So does this mean that if one decides to sue for damages, such as in a case of death from a drunk driver, one should do this in a common law court? Since we all know that majority drunk drivers never face monetary penalties from the plaintiffs. Excellent point. I would say that's extremely likely because that is where the harmed party should go for proper remedy at common law, is to a common law court. If you're a statute entity going into a statute court where the driver is a statute person and it's all about the insurance and various other things up there, yeah, I'd say that's a possibility. I don't know for sure, but I'd say that's a possibility. Kind of like O.J. Simpson was found innocent at the criminal level because it was beyond a shadow of a doubt that the standard wasn't met, but he was subsequently sued at the civil level and sued for damages. So yeah, that's a possibility for sure. Oh, and here's a suggestion: going after professional accounting associations. Absolutely. Going after the law societies. Because they are the ones who have they take an oath to their association. They have their own policies and procedures, and they have their own code of ethics and code of conducts, all these associations. Okay, all of those things are the standards for which they are to be held to. But if we don't hold them to them, they're just recommendations. So yes, professional accounting associations of the Law Society. I was reading some stuff in the Law Society today, which made me absolutely go, yeah. They are a private association with a monopoly. Actually, it was from the Governor General's speech. They are a private association with a monopoly over the law game. Okay, they have no outside regulation. I'd say that's a potential problem, considering what's going on. And I mean, there's a place in the States where somebody's trying to make it a law so lawyers cannot be put into positions of political positions. They can't run for office because the lawyers write the law, they prosecute the law, they adjudicate the law, and they basically get to do whatever they want in our world because they're all playing these fiction games. So I found that to be an interesting idea as well. What is your definition of full capacity? My definition of full capacity is what I explained before. At 18, prior to 18, you're not considered to be of full capacity. They deem you not to have full knowledge, not to have full liability, and not to be able to be responsible for your actions. So prior to 18, you're a private person, but of limited capacity, because somebody else is responsible for your actions. After 18, you're considered by the courts to be of full capacity until you prove otherwise. You're considered to have knowledge and be liable and be responsible. So in my understanding, a private person of full capacity is a person who knows the law, is responsible for their action, and is liable for their action. And the example I use for that is, you got a kid who has a baseball go through a neighbor's window, and the kid can do what? He can run away and hide. Not very responsible, right? Guess what? He's not a full capacity. Or he can go up to the house and say, "Give me my ball back," right? But not talk about fixing it or paying for it or anything. And the most responsible would go up and say, "I'm sorry, my ball went through your window. I will pay for the damage and the repair." So he knew it was an accident that he had caused. So he had knowledge of the difference between right and wrong. He admitted responsibility for it, and he took liability for it by willing to pay for it. So to me, that's the definition of a person of full capacity: knowledge, responsibility, and liability. And we're all, again, trained to be irresponsible. Everything's insured, limited liability. It's all about somebody else paying, etc. So yeah, the game is set up to make us wards of the state, so they, I believe, have an excuse to protect us and shear the sheep. I've got a comment here. Yes, Section 39 worked for me when the officer tried to tow car to impound yard. I claimed that, Section 39, and told him and the tow truck guy I'd charge him with auto theft. So great. So there's an example of, again, knowing the section of the Act and saying, hey, I have a claim of right to this, and if you take it, it's theft. And that is somebody saying, I know my right, I know the remedy, and you've been put on legal notice. And if you break the law by harming my person or property, I will hold you accountable. And most people don't want to go there. So again, you have to do it with certainty. You have to do it with knowledge. So very good. Thank you for sharing that. Good story. Any other comments? If you haven't, let's see. Oh yeah, natural versus private. Explain more. Okay, the natural person versus private person is covered in the Hope for Justice workshop on private-person.com. So if you go to the last drop-down tab, it's in there. In very brief summary, the natural person is a legal term which exists in both civil law and common law. So it bridges both worlds. So if you use the term natural person, they might assume you're the civil law version of it. Okay? Private person is the original term that was used only and exclusively in common law. Because privacy rights do not exist in civil law, if you put privacy or private in front of anything, you've automatically put it into common law, because you've modified the term you're using with the word private. And if it only exists in common law, then that means it's common law and it cannot be the civil law variety. The bijural terminology is the term which you can go and look up on the there it is in the text box, bijural. Just type that into bijural terminology. It'll come up. It came up first link for me last time I put it into Google. And it's the beginning of the write-up on the fact that because the federal government writes laws for Canada, and Canada consists of two jurisdictions, bijural, they tried to modify the federal law so that the federal law would fit into both jurisdictions. So every term that only existed in common law, they tried to find a word that also existed in civil law in order to be able to write one law for both jurisdictions. So that's why they changed the use of the term private person to natural person, is to try and make it fit the civil law world. Well, I don't want to accidentally get fit into the civil law world, so I avoid the use of the term. If I use natural person, I'll say natural person in private capacity, and that gives the clarification to take it out of the gray area. But I just use natural or private person to begin with, so that for me there's no uncertainty. Hopefully that answers that question completely for you. And like I said, there's a lot more detail in the webinar. Oh, there we go. Oh, there we go. Okay, got the answer. Good. Okay. We're coming up to 9 o'clock. That's good timing. If there's any more questions, raise your hand in your control panel. There's a little hand symbol. You can just click on that, and I'll be able to open your mic, and you can ask a question. If you have any more questions you want to type into the text box, go right ahead. And if nobody's got any questions, I'll deal with the last issue here. So what I'm going to be doing is I'm going to be making you an offer. Remember, everything's an offer. I'm going to be making an offer for participating in my research. As I continue down the road, the main things that I'm going to be focusing on over here is this issue here with regards to peace officers in common law, laying charges and complaints. But I'm going to be going down the road of common law court and honor and dishonor. So basically, if you want to participate with me, so I share my information as I go through the process, and my own study process, combining and reducing whatever I'm learning down to its simplest terms so I can understand it. If you want to participate in that process to learn about honor and dishonor, to learn more about the common law court, to learn more about this idea of your relationship to civil government or civil servants, and you know, the beginnings of you know, common law actions and actually laying complaints, because I believe that's largely where our remedy lays. I'm going to be doing a 2 times per week webinar study group. So there is 2 time frames. 1 time a week is not enough, and 2 times a week is required in order to hit the topics. There's going to be homework assigned, which is going to be reading material, videos, audios to listen to, etc., with interactive discussion on the webinars about material. I'm going to bring my conclusions, my understandings, etc., to each webinar. I'm going to be beginning it this Saturday, and it's going to go for 8 weeks. So it's going to be Tuesday night, Saturday, each week for 2 hours. The Saturday time, right now, I'm planning on 3 p.m. to 5 p.m., but based on feedback, that might be adjusted as to what works for more people, if anybody's interested in this. So if you want to start this study process and you want to go down the road of learning more about this stuff, I am asking for a donation to participate. And then, like I said, it'll be 2 webinars a week, 2 hours on Tuesday night, 2 hours on Saturday. The webinars will be recorded and made available as soon as possible for people who are